address the reference. Excuse me, I just want to address what my learned friend said, Chair, in the context of raising it today. The Commission sent our client and his legal team a letter yesterday on the 24th of June, where this was raised, and I'm not sure if my learned friend or the Commission itself have seen our response to that letter, also dated the 24th of June. The only thing I want to emphasize from that 24th of June letter, Chair, is what is...
Sir, before you go on, are you saying that the possibility of subjecting Mr. Karim to an examination by a specialist of the Commission's choice was raised for the first time in yesterday's communication?
No, I'm not saying that.
Yeah, I'm asking that so that it does not appear to all concerned that's what you are saying.
I'm only addressing the content of the letter of yesterday as it responds to the letter of yesterday from the Commission, which I understand my learned friend to be foreshadowing with you today.
I understand you, but I just want the fuller picture out there. That it was not the first time yesterday.
Unequivocally, I say on the record it was not raised yesterday for the first time in the correspondence. It had been raised prior, and the parties have been engaging on that. I'm just limiting it to the exchange yesterday and as it comes in front of you today. All I want to say, Chair, is that in respect of that contention or submission that is an available avenue to the Commission, in our letter of yesterday, particularly paragraph 10, you would see that certain issues were raised, and those issues were raised with the purpose of saying, and I place this on the record as well, is that once that is clarified, our client can then be informed of what the position of the Commission is, and he can exercise his rights to the extent that he can, and give us instructions to the extent that he can. So,
may I just raise this in the context of claims arising from, for example, bodily injury, medical malpractice. Such examination happen as a matter of course. One of the issues raised in the letter we received, I think, at night, I might be mistaken, is the question whether there is a suspicion that, I'm paraphrasing.
Yes, I accept.
That Mr. Karim is not in fact suffering from what is stated by the doctor.
Yes.
Bearing in mind what I've just said about this happening as a matter of course, would you say in those cases it happens because there are suspicions?
No, but may I qualify my answer on the following two propositions?
Yes.
The first one is the regime that the Chair is putting to me is firstly in the context of medical negligence claims or damage from medical negligence, which we know arises under a prescribed procedure under Uniform Rule 36, and related proceedings under Uniform Rule 36, where there's the contestation between parties and the need for independent medical examination to determine the extent of damages claimed and verify all of those. Without going into the merits of that, all I'm gently going to say at this point is that firstly, we're not in that terrain, and secondly, there's no equivalent procedure in the regulations, the Act, the rules, or the Commission's own rules that remotely cater for an equivalent procedure.
I saw that your letter actually raises that, and it's asking for the legal prescripts that make it possible for the Commission to insist on something like this. The prescripts governing the Commission's process provide, for example, that the chairperson may regulate the Commission's process. Based on your point that nothing comes anywhere near entitling the the commission to order something like this, would you say that that power, for example, the regulation power, would not be sufficient for the exercise of such a power or to make such a direction by the commission? If so, why not?
May I qualify my answer first by saying I'm addressing the chair's questions to me in general and in a hypothetical discussion. So nothing that I say must be construed as committing my client to a position one way or another. I understand the chair and I are having a debate about remit and powers. So I just want to make that.
It's just a virus issue.
Yes,
you are raising a virus issue and I'm engaging you at that level.
And because we don't know what the Commission's view, and when I say the Commission's view, I mean the evidence leader's view of the medical evidence is, and its deficiencies or otherwise, I need to make that clarification that I'm not committing my client to a version preemptively without knowing what the Commission's stance is. That's my clarification. But Chair, and this is still the first issue I want to address, you know that previously when we've appeared in front of the Commission, we raised an objection, to example, for a certain line of questioning that our learned friend was putting to the witness. My learned friend, Mr. Bana, was appearing on that occasion. Chair is nodding his head, he remembers that very well. And one of the preliminary objections raised to the line of questioning with the reservation of rights was that the line of questioning fell outside the mandate of the Commission, and that we reserved our client's rights to place that in issue at the appropriate time. Now, Chair, that answer is background context in response to your question on V-Rays, because in as much as obviously you have on the desktop version, you have an unfettered power to create the appropriate...
It can never be unfettered.
Well, that's the point. Well, Chair helpfully preempts me to where I was going to go, is the question of the degree of the fettering of your power is tied directly into the issue of the mandate. So without going into a full debate as to whether or not that falls into or outside of your mandate, I'm just flagging at a broad level of proposition that that's one concern we have. But also there are other concerns that we have, that they are potentially less intrusive means that the Commission has available to it, other than to subject our client to medical examination by a medical expert that he does not necessarily consent to. It's a compelled examination. That's how we understand the proposal being put, and that which potentially breaches his medical rights whilst under treatment by a treating doctor in a manner that potentially breaches sections 14 and 15 of the National Health Act. And that creates a question of V-Rays and competency insofar as the exercise of your discretion is concerned, if you're invited to do that. So that's my first bundle of concerns, if I may, in response to you, Chair. The second...
If a ruling or directive from the Commission were to direct that Mr. Karim avail himself for such an examination, but be couched in a manner that does not make it obligatory that he do so, but of course, bearing in mind the fallback position that Mr. Shaskalson has placed before us, in the event that Mr. Karim does not do so, would that take care of your concerns about the statutory prescripts that you are referring to? Because then he can just opt out and say, I'm not going to do it. At this stage, this is just engaging at a legal level.
Yes.
I'm not saying that's the way I'm going to go.
Yes. No, Chair, can I say firstly, I'm indebted for this exploratory discussion in the way that it's occurring, because it's helping clarify for me, and also I would hope for the Commission's evidence leaders, about these concerns which are legitimate concerns. And so again, the first point is I'm not committing my client to aversion in response to what Chair has put to me, but can I say that I have two responses to this hypothetical directive. The first one, of course, is it depends on the nature of the request, once specified by the Commission for such a ruling and directive, which my client must then be given a full opportunity to respond to. So I can't in abstract just say, well, if you try to design an equivalent confidentiality regime, like Chair will know from the HSF judgment in our circumstances, attenuated for consent, that I can agree to it. I first have to see what the Commission's position is. In theory, that might not be objectionable, but it might still be objectionable if there's a V-Raise challenge. So the creation of the regime does not answer the fundamental question if it's still ultra V-Raise. So that's as far as I can probably take it. The second thing I would say is that if it's attenuated to being voluntary, that might not be objectionable in and of itself, but then it depends on what weight will be placed on the election that is otherwise voluntary to ask the Commission to draw adverse inferences against my client for not participating in a voluntary request. Because remember, in the recent exchange of correspondence between my client and the Commission's position is that we've asked you, it's reasonable, you're choosing not to do it, and if you don't do it, we're going to ask the Commission to make inferences against you.
Let us say you were the decision maker, and the upshot of all this was that Mr. Karim ends up not testifying at all as a decision maker. And faced with the evidence that you have, how would you handle that evidence? I think it would be quite odd if, for example, we were suddenly to say, a lot of evidence was heard before the Commission, but because Mr. Karim could not have his last word on it, therefore, everything that relates to the bit in respect of which he did not have his last word will just be ignored altogether. So how, if you were the decision maker, how would you handle the situation? I'm raising this in the light of your point about adverse inferences being drawn.
No, Chair, I think we must disaggregate the adverse inference point. I'm talking about the adverse inference in this